Okay, may I permitted to mention one urgent matter?
Yes.
Tomorrow is the date fixed. Execution proceeding was stayed.
Yes.
Due to urgency in the
What is the impugned order?
impugned order, my execution proceeding was stayed.
Yes.
But I failed to enjoy the fruit of the decree. Lordship, kindly
Please
tomorrow.
come tomorrow. Yes, call the next matter.
With the lordship, may I be permitted to mention one matter
extension printing order
to today's list and CO 646
Item number?
256 of today's list
Yes.
and CO number 646 of 2025. My lord, the only reason for humbly beseeching for lordship is that the next date before the SAT is on 6th of July and they are proceeding with the final.
That.
Yes, your lordship, we have Securities Appellate Tribunal. We have approached them before your
What
lordship.
is the next date?
6th of July, your lordship. Your lordship has heard this matter.
Please come tomorrow. Yes. Call,
Malad is mentioning for extension of interim order Malad expiring this Friday.
Please hand over the slip. Yes, call the
Yes. Very well.
List item number 56 for expeditious disposal, Lordship. Kindly fix it 2 p.m. Lordship.
What is the urgency?
Lordship, expeditious disposal. This is
No urgency. Please come tomorrow. Yes.
I'm for the item number 1, madam.
Yes.
Commissioner. I prayed before your lordship to release this matter from this
Section
bench.
24 application, my lord. This is section
Section 24.
Yes, my lord.
For want of determination.
Item number 2, Lord. Not only for the judgment.
Yes.
Lord, yesterday, Lord, I had said that, Lord, on finality issue, I'll just hand over a judgment. Lord, this is a 68 Supreme Court. Lord, this is a Constitution bench judgment. Para 5 and 6 may be taken note of. তোমরা কোনটা দেখাচ্ছিস? এই পারফেক্টো। এটা কোন?
Perfecto, Mr. Kaur, you are relying upon.
No, this was relied.
Perfecto is Mr. Chatterjee.
Yes. Lord, perfecto is with respect to Lord right
Which
of
paragraph?
Lord, my lord will kindly come to Lord 11 first. That's the submission. There is no provision for revocation of leave already granted under 12A.
Paragraph 11.
Paragraph 11. That was the issue.
Yes.
And Lord, kindly comes to 23,
Paragraph 23.
my lord. 24. Another contention raised by the plaintiffs is that there is no provisions for revocation of leave already granted under 12A of the commercial. It is true that in Calcutta High Court commercial rules, there is no provision for revocation of leave granted for dispensation of provisions of section 12A. Under Order 7 Rule 11, the procedure has not been amended. Is such and such, Lord, it's there. In the present case, 26 and 27. But for revocation, Lord, my respectful submission, perhaps not the rigors of Order 7 Rule 11 is only not restricted to. Under 151, the court has power. Because once I can establish that, Lord, I have, Lord, the leave that was obtained is by virtue of some fraud or, Lord, some misrepresentation, Lord, then there is no question of, Lord, Order 7 Rule 11. Order 7 Rule 11 comes at a point of time when there is no leave.
Lord, please take note of para 23 first.
Yes, Lord, I have placed that. 23 I have placed.
Uh, 23.
23. In the
Yes.
present case, has your lordship got that?
Yes, yes.
Though the plaintiff had prayed for leave for dispensation of provisions of section 12A of the Commercial Courts Act, but considering the plaint as a whole, the documents relied by the plaintiff and the cause of action for filing the suit, this court finds that initially on the same cause of action, the plaintiff has filed an application under section 9 of the Arbitration Conciliation Act on 7th December 2017, and on dismissal of the same, the plaintiff filed a suit before the Alipur court on 20th September 2018. And after withdrawal of the suit on 10th October 2018, the plaintiff has filed the present suit on 21st May 2022. The plaintiff also not prayed for any interim urgent relief in the plaint. Thus, from the facts and circumstances, etc.
Yes, that is one part.
Yes.
And what is the relevance of Order 7, Rule 11 in paragraph 24? Yes, Mr. Chatterjee, what is the relevance of Order 7, Rule 11 with Section 12A? Because the observation of the coordinate bench is that since Order 7, Rule 11, there has been no amendment, so revocation is permissible.
This type of noise, if it comes to the ears, it feels that some missile is coming from somewhere.
What is the effect of Order 7, Rule 11?
First of all, my respectful submission, your
Order
lordship,
7, Rule 11 has nothing to do with
No, no.
Section 12A.
nothing.
But the finding is that since Order 7, Rule 11 has not been amended, please come to paragraph 24.
Yes, my lord. Yes,
What is the
But-
relevance of Order 7, Rule 11?
but his lordship, my lord, answers it later
Yes,
that there will be a provision that it can be revoked. He says under Order
No,
7, Rule 11.
it's not sustainable. There is no provision. Please kindly come to paragraph
Contention raised by the
26.
plaintiffs.
Yes, please kindly come to the ultimate finding.
My lord,
Paragraph 26.
my lord.
At page 10, last line, last sentence.
Yes, my lord.
Considering the above, this court finds that the issue raised by the plaintiff that there is no provision for revocation of leave is not sustainable in view of Order 7, Rule 11.
So that is his.
That's
lordship-
difficult to understand.
Cannot-
That's the finding.
That's the finding, my lord. I understand, but
Para 25. There was an observation in party automation
Huh.
that taking strength from there, Lord, this argument was advanced. Para 25, Lord, the paragraph is quoted.
Yes.
You kindly see. Lord, kindly come to the last 4-5 lines. The sentence
Yes.
starting with the word, as would be the case. As would be the case.
Yes, yes, as would be the
Where
case.
the plaintiff in a suit under Act does not plead circumstances to take his case out of the requirement of Section 12A, that is the urgency, the plaint should be rejected without issuing summons. Undoubtedly, on issuing summons, it will be always open to the defendant to make an application as well under Order 7, Rule 11. In other words, the power under Order 7, Rule 11 is available to the court.
That is because of if from the plain it appears that no urgency is there, so because Order 7, Rule 11 on a bare reading of the plain, it can
once
be.
clause 12 below is not taken and the suit is proceeding, then Order 7, Rule 11 comes
That is
into
a
play.
different thing. That
This is on that.
yes.
This is not on a situation where, my lord, where leave is granted and I'm praying for revocation.
151.
So these may not strictly apply to the facts of
I
this
am not,
case.
my lord, not saying at all. I'm saying it can be revoked. Your lordship wanted to know, my lord, whether it can be revoked or not. Because that was the observation from my lord that is there a provision?
This is can be revoked in a case where
It is not the subject matter before your lordship at all at the moment.
but it does not answer that when leave is granted, it can be revoked.
I bow down. I bow down on that.
This is
That's what-
subject to
that's what-
correction by you. It's not an authority for that proposition.
My lord, if this is so, my lord, that situation comes in when that application is going to be heard.
Yes, yes, that's the yes, and Mr. Kaur,
Paragraph 5 and 6, your lordships may kindly consider. It
which-
said that a point is taken and Lord, a writ petition or Lord, a proceedings is dismissed. Lord, that should be construed as res judicata. If it is an unreasoned order, it will not. But Lord, if the order contains some reason, then Lord, it will be res judicata.
Fail করেছে তখন গিয়ে ওরে-
This is 68, Lord, paragraph 5 and 6 may be kindly taken note of. Taking note of the earliest constitution bench judgment, this judgment was telling.
But this is not on special leave petition, because in special leave petitions, there are certain judgments which
Article
says when it will be,
It's about 226 and 32.
yes.
Lord, here, this a specific case is here that in the SLP, this point ground was categorically taken.
Yes.
Lord, one case is that, Lord, constructive res judicata, that, Lord, you don't take the point. Order 39
Rule
rule
have taken, not taken.
or not taken. Order 39 rule 4, order 7 rule 11, not taken. But Lord, when it goes to the Supreme Court, point is categorically taken. And Lord, Supreme Court dismisses the petition, and there is some reasons given by the Supreme Court.
Every submission of my learned senior friend is on merits. I am not on merits.
All
at
right. First,
Milord, I do not want to.
that's
Milord,
your
if your
choice.
lordship rejects
No,
it,
no.
Milord, rejects it. I don't have a problem. But if it goes on, my entire
That is
exercise
for
will be your
Mr.
lordship.
Chatterjee, that is for you to take steps there.
But at least give me that leave. At
That
least
leave
give
is
me
always there. That leave is always there. What
It's
steps you have?
the learned judge is not hearing us at all. But if I had
There's a
some
High
sort
Court
of
judgment that within
I-
6
some
months, the
sort
suit
of,
has to be
Lord,
disposed of.
Milord, then the matter, Milord, becomes infructuous.
Why?
If the leave is not granted, Milord, if
Yes.
rather the
Mr.
recalled.
Chatterjee, this is an application for occupation charges. So even if it is, let us assume it's allowed, and subsequently your application is also allowed, what will be the effect?
My application is not being heard.
Let us assume that today the occupation charges order is passed, that is disposed of. And subsequently, your application for revocation is also allowed. What will be the effect? What do you say? Why do you say it will become infructuous?
Milord, then what happens is if he gets an order, Milord, in that order 39 rule 1 and 2, and I come back before your lordship, then the money will have to be deposited.
If the leave is gone, everything goes. If
The
the
application is to be heard.
yes, it will be hard. Who is saying it will not be hard?
Direct said to be heard today.
Which application?
My application.
Mr. Chatterjee, that is the subject matter of this civil.
Exactly what I'm trying to say.
Yes.
Much
Let's call the next.
Milord, if there is no stay, Milord, then the suit will proceed today at 3:30. Kindly appreciates that the situation becomes irreversible.
Tendency of this application.
Your Lordship, appearing for the opposite party. Yesterday got the brief. Your Lordship, before extension of the interim order, Your Lordship, I would like to place one document that
My suit has been stayed at my instance.
is why it is so. Your
The
Lordship,
Lordship's order of 3rd March.
or during the pendency of the suit.
Your Lordship.
Yes.
In fact, my lord, one more judgment.
Now what do you want?
No, my lord, I want extension. That's why it was
Your Lordship,
mentioned.
kindly.
Because this
Your
has to
Lordship,
be
why?
said.
Yes, Your Lordship. Kindly allow me, Your Lordship, for 10 minutes, Your Lordship. Plaintiff first submitted their affidavit in chief in 8/2/2017. Till date, they are trying to evade the cross-examination, but they have done some cross-examination. So I will like to point out two part of the cross-examination. One is of 1/10/2018. No fresh lease deed was executed after 1984 in favor of the plaintiff's company. Plaintiff is claiming that he is the owner of the company or the property by way of lease deed. Thereafter, Your Lordship, on the last cross-examination, in the year 1984, second registered lease deed was given for another 5 years. Thereafter, Your Lordship, after the expiry of second lease, no further lease executed. After the expiry of the second lease,
You are submitting on merits.
yes, Your Lordship, kindly,
So I hear the merits. I'm extending the interim order.
Lordship, in a modified manner, let him conclude the evidence part. Kindly, only that part. Let him conclude the evidence. It is his case. What is the dual? 20 years pending.
So all I am saying is that let him deposit since he's so, my lord, anxious about my suit, let him deposit the occupational charges without prejudice to the parties' rights at the current market value. Deposit it. I am not saying give it to me. Let him deposit it in the High Court.
Let
subject
him
to the result of
establish
the
the
revision of
prima
application.
facie whether he is in the capacity to establish it.
I am not saying arrears. Let him continue depositing from
First of this, what is the suit for?
eviction. Eviction.
Eviction under?
Under the Premises Tenancy Act.
So, where is the provision for payment of occupation charges
No, my lord,
during the
that-
pendency of the
No,
suit?
my lord,
Please
there is-
satisfy me on that.
Yes, well, that is what we wanted to argue. My lord, there are Supreme Court judgments which says
On
that,
West Bengal Premises Tenancy Act.
well, my lord, it is on other rent control acts as well. My lord, what I am respectfully submitting, my lord, the issue that will eventually be decided,
Mr. Bose,
we
there is-
applied,
There is only thing is that
my lord.
occupation charges cannot be because Section 7 says
Right.
at the last rent paid,
Correct, correct,
they have to deposit.
right.
They cannot be compelled to deposit anything more than that. Where is the provision for occupation charges?
No, my lord, if your lordship will kindly see.
Show me if you want to rely upon the decision. Yes, please.
Well, there are 3-4 decisions.
Yes, yes.
Kindly keep it on any day, my lord. So this is the only issue, that whether in a eviction proceeding under the Rent Control Act,
2024-8.
there are two more which has come. Sir.
The admission was on the basis of this. Please show me which paragraph you are trying to rely upon.
Well, Lord, today I am not ready with them.
Mr. Bose, you are
Yes, of
on
course.
the of admission. You are
I
there.
did. 2024 8 SCC 668,
Yes.
and there are two more,
Yes.
my lord, which effectively says that,
Yes.
my lord, even during the pendency of the proceeding,
Yes.
my lord, of course, this is our interpretation,
Yes.
Lord, considering the changed circumstances and the fact that the person in occupation, my lord, can be allowed or can be directed to pay the current market rate. I am not saying whether by way of occupational charges or not, subject to the result of the suit. I will not appropriate that. He is enjoying the property.
Mr. Bose, please show me from this judgment that this was during the pendency of the suit.
Lord, the
please show
Vijay
me.
Kumar, Manish Kumar.
Yes.
Kindly give me a moment, my lord. Vijay Kumar, Manish Kumar. Vijay Kumar, HUF, occupational charge. My lord, kindly take first. Yes. My lord, paragraph.
Or if you want to bring the other judgments, I can keep it on
Yes, my
another
lord.
day.
Yes, my lord. Kindly, there are two more other judgments also
Yes.
after Vijay Kumar,
Yes.
which includes Martin Harris as well. My lord, this was a situation where the tenant had not suffered a decree. But it would be para 21 words. I have by notice under 6(4) terminated his tenancy.
Yes.
My lord, now the
After
situation.
termination,
Yes.
unless you serve a notice, you
Yes.
cannot file a suit for eviction. Now,
Naturally.
once you file a suit for eviction, the summons is served.
Right.
What they are obliged to do?
Well, if there is any arrears of rent, either pay at the last paid rent. But what I'm saying that during
And that if they comply with that,
yes,
that's the protection against eviction.
no, it is, but
So how can you claim? How can you claim any extra
so
amount?
protection against eviction if it is a eviction suit on the ground of default.
No, who says so?
No,
Kindly come to section 7.
Right.
On any one of the grounds. It does not say only on the ground of
no, but
default.
so if I succeed on other grounds,
Yes.
so well, that by itself does not give him a protection.
Mr. Bose, please come
Yes,
to
madam.
section 7.
Yes, madam.
It does not say only on the ground of default.
No, I am not saying that.
On any of the grounds. So the suit may be on any of the grounds.
The ground.
So they are really required to, and you will find in section 7(1).
Well, this is a tenant's obligation under the act.
Yes.
Right.
So if the tenant's obligation is to perform,
Right.
please see the heading.
Right.
When can a tenant get the benefit of protection against eviction?
Right.
So if he complies with that,
Yes.
he gets the benefit of protection against eviction. During the pendency of the suit, you cannot claim any further amount.
No, that's whether I can or not, that is the
That's the
situation.
statute.
No,
That's the statute.
what I'm trying to that statute does not, my lord, prohibit payment of any rate after the last rent.
Show me that, Mr. Bose, show me that the landlord instituting a suit for eviction
My lord,
can claim
yes,
any
can
amount.
claim. Yes, yes, yes. Sorry, this is, my lord, this is judgment law. My lord, this statute does not prohibit. If the statute does not prohibit,
Does not permit. Statute does not permit because, Mr. Bose, let us assume
yes,
an order is passed,
yes,
directing him.
my lord.
He does not pay. Consequences. Let us take that far.
Yes,
Court directs.
Yes.
He does not pay that. What's the consequences? Show me that consequences has to be provided under the statute.
right.
Show me the consequences.
My lord, so it will be violation of an order of court. Nothing more than that.
Show me that the statute violates.
Statute, I
Mr. Bose, violation, striking out of the defense is only under section 7(3).
that is for payment of arrears at the last paid rent.
Yes,
Well, I'm with your lordship, but I am on the other
You
aspect.
can be, you can come with
Change
the other,
circumstances.
you can
Now
come with the
Supreme Court
other,
is-
other decisions.
Very well. Any day convenient to your lordship.
Lordship, on
Till when it is the
7th of July. Evidence is fixed on 7th of July.
No, till which time this
Of June.
Well, 25th of June.
30 June.
no, end of
No,
June.
no, the end of June. The interim order is still
End of June.
end of June.
Tomorrow. Come tomorrow.
Tomorrow.
Civil obligation law.
Yes, tomorrow. Not today. Next. Item number 4.
My lord, I am led by Mr. Siddhartha Bhagat. I believe that he is appearing on virtual mode, my lord.
Milord, may I please your lordship?
Mr. Banerjee.
Yes. Milord, seated application, Milord, there was a probate proceeding. Milord, it was with regard to Milord, my father's will. I was Milord, the executor come beneficiary, Milord, PW1 as well. It's true that Milord, on some occasions, Milord, I failed Milord to appear and Milord to depose, which is why Milord, my evidence has been closed. My lord will kindly make a time frame, Milord, I will depose and conclude Milord, my deposition. This is all, Milord, that I want. Milord, by the impugned order, Milord, my evidence has been closed. Milord, that day, Milord, I was ill. Milord, there was, Milord, an Milord, application filed. But, Milord, the learned court was little annoyed with me.
7, 8 occasions you did not, even after last chance, special chance.
True,
Not only that,
true, Milord, true. But, Milord, this entire proceeding otherwise, Milord, would become infructuous. My lord will kindly, Milord, take me to talks if my lord so feels. Milord,
For your conduct, it has become infructuous. You did not you are not very diligent in proceeding with your suit.
Milord, no doubt of that. Milord, I cannot, Milord, say anything, Milord, more than this. Milord, records are ugly, Milord, for me. Milord, no doubt of it. But Milord, Milord, one chance, Milord, any day that Milord, my learned friend would, Milord.
I am the married sister.
All right. His
Milord,
evidence is closed. One day I am fixing. Have you filed?
In a day, Milord, I will.
The chief was filed not on 19th.
All right.
August
So
2020.
only Mr. Banerjee, chief is completed.
No, Milord.
No, Milord, it's not concluded. I will conclude it in a day, Milord.
Uh,
Milord, the interim order suggests that, Milord, I was, Milord, in the midst of examination in chief. Milord, I'll conclude in a day.
Him then to conclude the PW1 and the PW2. Then
How many witnesses you have, Mr. Banerjee?
I'm sorry, Milord.
How many witnesses you want?
Milord, that Milord, I need to, Milord, ask my client. Milord, that Milord is not quite sure.
Instructions, it should not be as vague as that. Where is the list of witnesses? How many witnesses you will adduce? Please come ready with that.
Very well, Milord, I'll do that. Milord. Milord, maybe any day, Milord, in the next week, Milord, I'll come with the list with witnesses proposed to be examined.
So why this is there? There is interim order.
interim order is there.
Yes, Milord, my proceeding, Milord, was stayed. It was my proceeding. Since, Milord, now, Milord, the learned judge of the court below was, Milord, of the view that it should go for, Milord, argument. That is why my lord was kind enough, Milord, to stay all further proceedings. But the interim order lapsed, Milord, at the end of May.
Today is the date spec.
Tomorrow kindly fix, Lord. You will only take instance.
Tomorrow, Mr. Banerjee.
Very well, very well. Milord will assist your lordship tomorrow. Very well. Milord, let nothing happen today.
My lord, may I be permitted to file the certified copy of the order, my lord, which I challenged.
You did not file it.
It was filed with
The
link.
certified copy of the order impugned, filed in.
For the petitioner, my lord, this is for my lord early disposal of the suit. My lord, suit is of the year 2016. DW2 was even closed in the year 2022. My lord, may kindly come to the page of list of dates. Your lordship will find numerous occasions, my lord, matter has been adjourned. And due to filing of one application, my lord, under Order 8, Rule 9 by the defendant in the year 2023, that application is still pending, my lord. My lord, kindly.
This application under Article 220.
My lord, I am for the petitioner. My lord, in this matter, the claimants filed a case out of which they received an award of rupees 7,55,000, amount of rupees 7,55,440. Assailing that award, the insurance company came up before this Honorable High Court. The Honorable High Court and the entire amount was deposited in August 2018 along with interest. Now, what happened by an order dated 1st of August 2019, the Honorable Division Bench was pleased to dismiss the appeal, directing the insurance company to amount that has been deposited before the learned registrar. The claimants were entitled to get that award upon furnishing due proof. Now, this amount was, my lord, 9,77,477. Now, what happened? After a couple of years, suddenly an execution case was filed, inter alia alleging that still an amount of rupees 61,000 and odd is still pending from the insurance company. The insurance company said that since I have already deposited the entire amount by dint of the solemn order of this honorable court before the learned registrar, along with the interest, whatever dispute, if at all, is interstate between the learned registrar and the claimants. The insurance company cannot be, because it has this award has already merged with the order of the Honorable Division Bench. In spite of that, my lord, the execution case has proceeded. I have assailed 2 orders. Now, my lord, let me be very candid and divulge one thing. I have already come up before my lord once. Since these 2 orders that I have assailed, further I went in for a review application. That review application was dismissed. Neither it was on the ground that there was a delay, so that delay was not allowed. But the learned executing court went into the merits of the case. So my lord was pleased to say that this is not correct. So this has been kept. So that is still pending, my lord. This is pending in the monthly list of July 2025. Now, my lord, these are the 2 orders that were passed prior to that order of review, my lord. Kindly, my lord, takes up the impugned order once, my lord.
You are challenging the order dated 6th of December 2022.
And subsequently, my lord, 24. My lord, there was, I understand, my lord, there is a delay. But my lord, there is also a review application which my lord had been pleased to.
Maybe. Review application will be considered when it comes.
Then, my lord, these have not merged with the review. These are separate orders.
That I do not know. This application, December 2022, 61,000. Sir, why are you not paying this 61,000?
Because, my lord, I have deposited the entire amount with the registrar.
All right.
So, my lord can always call for records and see that.
For the records, I will not allow you to challenge this order of 6th of December 2022 in 2025.
So then 2024, my lord.
2024 is nothing. 2024 is only to bypass that.
So the review is still pending. Then my lord will take the
review of which order?
This 2024. Thereafter, I prefer the review application.
If the parent goes, review also goes. This application.
My lord has.
petitions. But the petitioners are the defendant number 2 and 3 in a suit for declaration and injunction. But after appearing in the suit, enter appearance in the suit, they file the WS, and thereafter may not file an application under Order 7, Rule 11 of the Code of Civil Procedure. But the trial judge held in my favor. Thereafter,
Order 7, Rule 11 allowed.
Allowed. Thereafter, the appeal was preferred. The appellate court has set aside the order against which I have come up. We have come up.
Do you have the order? This point was whether a civil revision is maintainable against this order. There is a decision. Have you got that?
That is not the appellable order. Therefore, not civil revision would like.
There was a reference on this point.
The suit would be proceeded with.
Nothing will happen. Yes.
No,
You can take it. Your point is maintainability.
Maintainability.
That will be an issue in the suit.
Hit by the Benami Transaction Prohibition Act.
Yes. So that will be an issue in the suit. You will not be affected even if the suit proceeds. Yes.
My application, Lordship. Petitioners are defendant number 1 to 4 in the title suit for injunction and declaration filed by the opposite party's plaintiff, Lordship. There I filed an application for amendment, Lordship. That was not allowed on the ground that there is no nexus between the present suit and the suit which I want.
Show me your amendment.
Lordship, it is at page 60. The amendment application is at
60.
60.
Yes.
Lordship, the proposed amendment is at page 60, paragraph, Lordship, 2, 4A. Paragraph 4A, Lordship, is the proposed amendment which I want to bring on record in my written statement. May I read, Lordship, that prior to the filing of the present suit,
Is Shubhashish Rai a party in this suit?
Lordship, my predecessor have the
No, I'm
predecessor
asking,
of the plaintiff.
please answer two questions. Is Shubhashish Rai a party in this suit?
Not in this suit, Lordship. My predecessor, plaintiff's predecessor filed a suit against my predecessor, Lordship.
Yes.
And I want to bring on record that suit which was dismissed.
Where have you stated that? Nothing has been stated.
But you could see that prior to the filing of the present suit, Shubhashish Roy filed TS number so-and-so before the learned first court at Asansol.
But you have not described where the
But
predecessors.
you would see my main written statement where I have stated I want to
The
elaborate.
statement will not be considered at this time. This amendment you are trying to say there is no nexus. You have not said anything as to how these proposed amendments are necessary, how that suit is related to that, what were the reliefs, nothing has been stated.
Lordship would take, I am the defendant, Lordship. I have filed my written statement there.
I appreciate that, madam. You
stated in one paragraph about the suit.
Your endeavor is to say that the present suit is barred by res judicata since an earlier suit was dismissed. That's your case. So from this proposed amendment, you have not linked how the earlier suit and this suit has been linked.
Lordship would kindly take my written statement once. Lordship would kindly take my written statement, which is at page 53, Lordship.
Yes.
53. Lordship, may I read paragraph 5? Paragraph 5, Lordship.
Paragraph 5, yes.
Which is my written statement that the plaintiff earlier filed similar suit before different civil court at Asansol over the self-same alleging, and the said suit was dismissed by the learned court. The defendants crave leave to your court honor to refer to the same at the time of hearing of the suit. it is hereby submitted that the defendant, one Subhashini Roy, filed TS number 62 of 44 before the learned first
Subhashini Roy or Subhashis Roy?
choice. What
But
the
you have said here amendment is Subhashis Roy. Please kindly come to page 60.
Subhashish Roy, Lordship.
And here you have said Subhashini Roy.
Lordship, I have annexed the plain copy.
Only
The
so
order
that amendment is already there in the suit.
Lordship, I want to bring on record detailed description. Date of the dismissal of the suit is missing in my written statement. I have annexed the dismissal order of the suit. Lordship would kindly see.
You can produce the judgment for that. You have said the basic facts are there.
Lordship, trial
Application.
has been commenced.
This application under Article 2.
My lord, I am for the petitioner. My lord, this is a suit for declaration and injunction, my lord. In the suit, my lord, after filing the suit, my lord, we have served the summon to the defendant opposite parties, my lord. The defendant opposite parties did not appear, my lord. In the suit is in the year of 2021, my lord. And after that, my lord, several dates had been fixed, but defendants is not appeared in the suit. The suit was filed ex parte, my lord. And when the ex parte hearing was going on that period, my lord, on 15/5/2024, the defendant appeared by filing. Defendant appeared and appeared before the learned court, my lord, by filing a Bengali petition with a prayer to serve the copy of the plaint, and the said petition was not supported by any affidavit or verification. My lord, the copy of the plaint has duly served to the opposite party's defendant, my lord. Thereafter, the dates has been fixed, my lord. They didn't appear, my
This
lord.
is the order which you are challenging.
Yes, my lord. Kindly come to The order dated 10/4/2025, my lord.
Yes, what has been done by this? What is the miss
My
case
lord,
for?
on the
What is the miss
miss
case
case
for?
for order 39, rule 1 and 2, my lord.
Miss case for order
No,
39,
no,
rule
my
1 and
lord,
2.
sorry. I'm sorry, my lord. The execution, my lord. Order 39, rule 1 and 2. After that, my lord, the
What
violation,
execution?
my lord, that
Violation, order 39, rule
violation of
2A.
order 39, rule 2A, that
Yes.
was the miss case, my lord.
Yes.
In that, my lord, 10/4/2025, my lord, that expert you had set aside, my lord, in the year 10/2/2025, they appeared by filing WS, my lord, and after
No, madam, you are
accepting
challenging the
WS,
order dated 10th
yes,
of
my lord,
April.
on
What is the wrong in this order?
yes, my lord, that was accepted, my lord. Expertise order was vacating by subject to payment of cost of ₹1,000, my lord.
Where is that?
Yes, my lord. Kindly come to page, my lord, 45, my lord. The order dated 10/2/2025, my lord.
You want an ex parte order. You don't want a contested hearing.
No, my lord, we want to contest the application, but my lord, on the next date, they didn't pay that amount, my lord. The matter has been again fixed for, my lord, the PH for discovery inspection, but they didn't pay on that day, my lord, the subject of the cost amount, my lord.
If they do not pay the cost, I will direct on that day to proceed in accordance with law.
My lord, kindly and pass, my lord, a limited period, my lord, to dispose of the suit, my lord, because this is 2021.
The petitioner is.
Yeah.
Stage. It's at the preliminary stage.
My lord, on 10/2/2025, my lord, the payment of 1,000 order has been passed, my lord. And
Yes,
that
it has been extended
on
till 10th
10/4.
of August. I have said if it is not deposited, it will proceed in accordance with law. Yes, call the next matter.
Item number 10.
My lord, this is a matter of suit and declaration, suit for declaration and injunction, and the petitioner defendants, they have appeared and contested the suit. On 12/3/2025, it was fixed for defendant witness in default closed, and eventually on the same day, the petitioners had sought for adjournment due to some unavoidable circumstances. But
What was the unavoidable circumstances?
my lord, the defendant number 2 in the matter is an aged lady, and she had undergone some eye surgery. So she was unable to appear for that matter, but the adjournment was rejected. And 23rd April 2025 was fixed for the next date. And on the same date, the petitioners had filed for affidavit in chief and for defendant witness and for recalling petition under Order 18, Rule 17. However,
Where is the recall petition?
my lord, it has been attached. My lord, annexure number C, page number 19.
19.
Yes.
By the order impugned, the for argument.
My lord, petitioners, the petitioners in this matter, the defendants, they have not been allowed to depose before the learned trial
What
court.
happened on 9th of June?
My lord, I'll take instruction.
Please take instructions and come at 12. এটা রাখুন। Powder. Please take instructions and then come.
My lord, the argument is ongoing. The argument
Please
stage
take
has
instructions.
started.
What happened on 9th of June? What is the next date fixed?
My lord, the next date fixed is 30th of June.
Please take instructions. What happened? Whether the argument is closed or not, please take instructions. Yes.
Number 11.
The title it is started in the year 2020. 30th day of September 2020, my lord, evidence started. PW1 is complete. Cross-examination is
What do you want?
experiences hearing, my lord. A
What
time
is the
bound.
petition dated 12th of March 2025?
12th of March 2025, my lord. The petition 12th day of March 2025, my lord, under section 140, defendant filed Hajira, phrase Vokalatnama.
Where is that application? Have you annexed that?
No, my lord, I have not annexed that. But from the date, my lord, I find that evidence is started, PW1 is complete. That is, my lord, 31/7/2023. 31/7/2023. Malavika Rudro alias Das is examined in full and cross-examined in part as PW1 and deferred for ends of justice. And I think it is, my lord, completed as because on 13/11/2024 it is written 17/12/2024 for DW, if any. 13/11/2024. So, my lord, dilatory tactics is being made by the, my lord, defendant.
Uh,
Hey, advocate on record.
The defendant is the petitioner before your lordship, but in a suit initiated for declaration of right title, interest and permanent injunction. The order 14 rule 2 application is being turned down after framing preliminary issue. So it's not that the initial application of my to invite the court to frame a preliminary issue, that was done, preliminary issue framed. Thereafter, it has been turned down by the order impugned. Why, my application is under order 14 rule 2? Because I, being a plaintiff, filed a suit for eviction, treating him as a licensee. That suit decreed, appeal, dismiss. Second appeal, a defective order 41 application is being pending. Thereafter, execution levied, possession handover, satisfied, execution case disposed of. Thereafter, this round of litigation, his defense in my suit for eviction of licensee is that I claim title from his predecessor by virtue of a deed. He said no, it's a loan in substance. By making a false.
So what is this suit for?
This suit again, his case is that it's a loan in substance. By mistake, this has been done. I have practiced fraud. So I take the ground of, and consciously in the plaint of the present suit, he has mentioned about the earlier suit. So I took out an application under order 14 rule 2 saying that it's barred by principle of res judicata.
Mr. Mukherjee, whether the issue of res judicata can be decided as a...
This will disturb your lordship. Now, in 2020, the Honorable Supreme Court said, yes, the point of limitation, res judicata is a mixed question of law and fact. So, order 14 rule 2 cannot be adjudicated. But if it is an admitted question of fact, then there is provision that yes, order 14 rule 2 stage also, the court can nip in the bud so that the future will not be avoiding the complexity and the wasting the time of the court. That is paragraph 52 of 2020.
But Mr. Mukherjee, that may be one way of, or I can, because the issue has been framed with regard to whether the suit is barred by res judicata, issue has been framed.
Not res judicata, kindly takes up the order impugned once.
No, you said that issue has already been framed.
Yes. that is thereafter considering the prayer of the defendant, the preliminary issue was framed by this court as to whether the instant
Which
suit is
page,
maintainable.
which page?
First page of the order, second page of the order impugned.
Second
Order number
page.
16 dated 10th of April 2020.
Second page, yes.
Yes. Thereafter, considering the prayer of the defendant, the first paragraph, last 4 line. Has your lordship got?
Yes, as to whether the instant suit is maintainable in law.
And in form.
Yes.
This is the preliminary issue that has been framed.
Yes.
Not everything is on record. The court can exercise. The court cannot say, since it's a mixed question, kindly once looks at the paragraph.
But Mr. Mukherjee, if the second appeal is still pending, good, bad, indifferent, it may be a defective order 41.
No appeal in the eye of law.
What's the defect?
Kindly takes up this one order. I have annexed.
Mr. Mukherjee, this cannot be an admitted
62.
This cannot be an admitted question because they will not admit that it's a defective.
No, Milord, that's why page 62. I have invited the court.
Yes.
That's why page 82, Milord, I have invited the court.
Appeal is defective. As a last chance,
yes.
Whether the appeal is pending or not.
Thereafter, nothing is being done on their behalf.
If the appeal is pending,
Milord, kindly consider that is, Milord, one litigation that is, Milord, originates from my suit for eviction of
only
license.
because you have taken possession.
No, I am not saying that, Milord. But today, what defense they have taken, let them thrash out, Milord, in second appeal. After all, thereafter 144, everything is over. Whether a fresh suit seeking same relief, which is the defense of their, Milord, in my suit for eviction of licensing, can be permitted to again go on. Because this, Milord, the suit, Milord, their defense has been taken care of, eviction degree passed. They preferred an appeal dismiss. Thereafter, the second appeal. Now a fresh suit.
But you could have taken other steps during the pendency of the second appeal.
Milord,
because the subsequent suit on the same cause of action, similar issues has to be stayed. So that ought to have been taken because now till now the second appeal is pending.
The problem, Milord, the difficulty remains he has obtained an order of injunction over here. So that's why I want to agitate these points that once for all, let this be decided. And paragraph, once, Milord, for my satisfaction, looks at, Milord, this is, Milord, reported in 2020, volume 6 SCC. Perhaps, Milord, it opens some little avenue because that was the settled law that I cannot. Milord, it is 2026 SCC, page 557. 2026 SCC, page 557.
Yes.
Kindly takes up paragraph 52 once.
Paragraph 52. So this is on limitation, not on res judicata.
That your lordship knows that is also a mixed question of law and fact.
No, Mr. Mukherjee, there lies the distinction. That distinction has been made here. In a case, question of limitation can be decided based on admitted fact.
My lord.
It can be decided as a preliminary.
That's why, Milord, I will invite paragraph 7 of the plaint.
In a case, res judicata is a different thing.
That's why, Milord, paragraph 7 of the plaint once looks at.
Of which?
Of their plaint new suit.
So,
they admitted.
Now this judgment may be a different thing because once you say res judicata,
and if
then the pleadings, the plaint, written statement, issues, the judgments, all are to be brought in.
That's why,
and that cannot be brought in unless its evidence starts.
That's your lordship's court decision that for the purpose of deciding order 12 rule, order 14 rule 2, a limited inquiry of the witness can be done.
This decision, paragraph 54 is on a 52 is on a different thing altogether.
I say, Milord, if it is mixed question of law and fact disputed by the parties, then my lord,
They-
your lordship,
Yes.
if it is admitted,
But res judicata is a different thing.
kindly see
altogether.
paragraph 7, they themselves stated.
What?
My lord, page 14 once looks at page 14, paragraph 7 of their claim.
Page 14,
Page 14, my lord,
paragraph 7.
paragraph 7, my lord, last portion. My lord, kindly read on, my lord, this paragraph only.
Yes, they have said paragraph 7 is very important.
Yes,
because finality, according to them, is not there.
Then
Because the
also-
second appeal is pending.
Yes, my lord, then, my lord, I join an issue. Very well, my lord, it has not attained finality, but that
It is not
issue-
attained finality, then it's not res judicata.
that issue,
It's not res judicata, Mr. Mukherjee. It's not res judicata. Because the second appeal is pending.
second appeal, my lord, in my respectful submission, if it is not an appeal in the eye of law, if it is a defective appeal,
Defective, curable defect. If it is cured,
yes, my lord, then that is the fora where he has to, my lord,
res judicata you have to show. Res judicata you have
my
to
lord,
show.
I say, my lord, until and unless, my lord, this issue which has finally adjudicated and not being
Not
stayed by-
finally adjudicated. Not finally adjudicated. Appeal is pending. Pendency of an appeal. So all the issues become pending. Finality loses. Finality is there when there is no appeal in the eye of, there is no appeal. So that's the finality. Once there is an appeal, all issues become pending. So finality loses when there is an appeal pending.
my lord, the appeal is there, my lord, they have to thrash out everything in
That is a
in
different
that
thing.
appeal.
So the finality is
whether
not
it is-
there. Mr. Mukherjee, finality is not there because they are trying to make out a case that was on the basis of a forged deed. They have obtained second appeal is pending. So according to them, that issue they will agitate in the second appeal. So the issues have not yet attained finality. Finality is not there. And unless there is finality, res judicata will not apply. So these are the disputed questions, not an admitted fact.
Then, my lord, kindly direct that issue, my lord, to be decided, my lord, at the time of, because this
Which
issue,
issue?
this issue has been framed. So instead of
Issue-
going into
The res judicata issue has been framed.
not
Where is
res
that?
judicata, my lord, the issue, my lord, I have shown before you.
That is your application.
Yes, my application. But my application is at page 68.
You have said on the point of maintainability.
Maintainability. But my lord,
You have also not specified that.
but paragraph 3. And in my written statement also, I have specifically taken this point.
Issues have been framed. What
No,
are the issues?
Only
You have said-
preliminary issue. That is, my lord, recorded in the order.
So I am giving you liberty that to raise the point of res judicata at the time of framing of the issues. Ashwin.
Lordship, I'm appearing on behalf of the petitioner led by my senior advocate Malay Bhattacharya.
Led by?
My senior advocate Malay Bhattacharya.
Yes.
Lordship, the marriage between the parties was solemnized in the year 2016. Thereafter, a male child was born in the year 2017. The dispute.
You are challenging the order of alimony.
Yes, Lordship.
You are the wife of the husband.
I am husband, Lordship.
Yes.
Lordship.
What is the amount of alimony granted?
Lordship, 12,000 in aggregate, 8,000 towards the wife and 4,000 towards the male child, Lordship.
What are you doing?
Lordship, presently I am unemployed, completely depending upon my widow mother's income, pension. Lordship.
At the time of marriage, what were you doing?
I was a daily labor, Lordship. I was working in Inscart Private Limited, earning rupees 5,000 per month approximately. I am still paying rupees 4,000 in aggregate per month as per the order passed by the learned court in 125 proceeding, Lordship. That order passed in the year 2021 and still I am paying that amount, Lordship. And
Where is your affidavit of assets and liabilities?
Lordship, this is. Lordship, it is not annexed. This is.
Your total expenditure per month is almost about 14,000. How are you managing that?
Out of my widow mother's pension, Lordship, somehow.
What is the pension of your widow mother? And also you are paying 4,000.
Yes.
So 17,000, 18,000 you are incurring monthly. This application under Article 2.
Due to bereavement in his family, he is not coming to the court.
On the prayer of the learned
Kindly
advocate,
grant me a fortnight's time, Lordship.
the learned advocate appearing for the petitioner, uh,
My lord, may I be permitted to mention item number 10? My lord, on 9th June, we have appeared, the defendants have appeared, arguments were started, but the learned trial court has postponed it to 30th of June for further arguments.
30th of June for further argument.
Yes, my lord. My lord, my humble prayer is that the defendants are allowed to depose before the learned trial court.
By the order impugned,
Two 36 of the 2019. This is a expeditious disposal petition filed by the wife. Till date, my lord, the evidence has not been completed by the respondents. And on the last occasion, they have taken the adjournment. They have taken several times adjournment.
miscellaneous case has been disposed of.
Yes, my lord.
What happened on 20th of November 2024?
20th of
November
2020.
It was fixed for evidence of the petitioner.
Has not yet been given, my lord.
What happened on 7th of March 2025?
7th of March, again they have taken adjournment, my lord.
Who has taken adjournment?
The respondents. Now it is fixed on 28th July. Further for the evidence of the petitioner.
Fixed on
28th July.
28th. Ashwin. This application under
This petition application against an order passed in a claim case by the moderation claim tribunal. But
Yes.
the claimant number one, my lord, she submitted her, my lord, against and chief. But she has not, my lord, cross-examined by the other side. That's why, my lord, subsequently, my lord, filed an application. But that, my lord, I invited her, but she has gone, my lord, without cross-examination. Subsequently filed an application, my lord, to, my lord, shift the case from the argument stage and, my lord, to recall the, my lord, PW1 for cross-examination. But that prayer has been rejected, not unless the PW1 is re-examined, cross-examined. His armored examination has has no value. So the claim case will not be decided, not
Seems that the claimant is not interested. 39 dates were fixed.
the blood is also kindly fixed on the blood last chance.
39 dates were fixed. What happened on 21st of August 2024?
No, there but adjourned.
What is the next date fixed?
Date was last date was fixed on 19th of June. It was again adjourned for last chance. And unless the blood she cross-examined blood case will not be decided properly, blood little last chance be given.
So please come to the impugned order. On 6th of June 2024, you paid for time that you will be challenging this order before the higher forum. And this application has been filed a year after in June 2025. Claimant is not interested.
But poor claimants from village people, poor claimants from village people. But they are very much interested.
This is the fact. 39 dates were passed. And even after that, you have filed after 1 year. After 1 year.
Kindly not consider the beneficial legislation act her claim will
This is beneficial legislation, everything. It's not the claimants, and the claimants are not interested to take that benefit.
Her claim
39 dates, and June 2024, they said that they will be challenging, and that application also filed after 1 year. No diligence.
No, Lord. Kindly not on chance. Last chance, Lord, is lots of give Lord. Otherwise, Lord, the case will go. Let's have a look. Kindly Lord, allow me one chance only. This is a fault on the part of the advocates. They did not file.
What steps have you taken against the advocate?
What?
What steps have you taken against the advocate?
What?
That advocate is still continuing. So it's difficult to change an advocate in a motor accident claim case. You know it better. It's very difficult.
Give me
Yes.
chance. Give me one chance. Last chance.
It's a matter of 2014.
Examination in chief has been filed unless she is cross-examined. Can you have it only one chance?
But not interested in cross-examining. 39 dates.
Anyhow, this has been done by the
Cost.
inadvertent mistake.
It has to be on cost.
Inadvertent.
How much cost you are willing to put in?
Poor claimants will have 3, 4, 500.
Yes, I could not hear.
Plus 300, 400, 500 as you.
500. 3 figures. I was thinking of 5 figures. And you are in 3 figures. 3 figures. 39 days and thereafter delay of 1 year.
My lord, you have to similar.
Even 5 figure is not sufficient.
But this is also a khalasi of the vehicle. How much he has earned? His earning was not 3,000 per month.
That I follow, but
3,000 per month. They have not yet got any single farthing. They are making more expenditure for this.
please produce the subsequent order sheets. It appears that
My lord, we are from petitioner. Please, I humbly request for a passover because he is now engaged in another court. Sir,
Lord, this is a pure level of the eviction suit.
yes.
One of the rent, 600, 700, 2,000. This is the suit value. Then they paid compensation 1,50,000 and filed the suit before the civil judge senior division. My petition, in
Yes, recovery of damage and compensation.
recovery of damage. Simple suit for eviction.
Maybe. Plaintiff can put his own valuation, nothing will happen. You know the decisions on this point. These are done in order to move before
Now, to avoid this is a forum to choice is forum. Choice forum.
Decisions on this, there are reported decisions on this. This application under
suit for declaration and injunction. Injunction granted by the learned trial.
What is the order impugned?
It is not challenged any order, my lord. Order is in my favor. But one miscase under order 39 rule 2A is filed.
Yes.
That is pending, and my lord, that is to be heard expeditiously because they are regularly violating the order of the learned trial judge. That is why, my lord, I prayed for expeditious disposal of the miscase number 28 of.
What is the stage of the miscase?
The miscase stage is a very preliminary stage, my lord. And my lord, long date is given, my lord, September, in the month of September. Unless it is expeditiously heard, my lord, relief granted by the learned trial judge, we will not enjoy, my lord. We will not able to enjoy, my lord. And they will not be prevented. And they are regularly.
1st of September for service returns.
My lord.
So unless it is served, how can it be taken up?
But at least, my lord, definite period.
Not at this stage. This application under Article cannot be expedited. You know better. Yes.
My lord, before my learned senior friend proceeds with the matter, my lord, my lord, Mr. Sanjay Mukherjee is appearing on behalf of the opposite party, my lord.
Yes.
Very well,
Due
beloved,
with
but I-
personal difficulty, he could not come to the court.
No, my lord, I am not standing in the way. What I proposing that this is not by virtue of my rejection of section 24 for transfer. But my lord, the learned judge, where the proceeding is pending, he on the last date, what happened, my lord, there is a cross-examination going on. So on that day, he ultimately, my lord, the cross-examination of the plaintiff's witness is being turned down, and my lord, he has closed the
suit has
witness
been-
of the
The
closed
suit
the
has
wit-
been transferred.
No, the true suit is being prayed for transfer on my instance, being the defendant.
Yes.
That has been rejected. Present revisional application arising out of that order. Rejection of my section 24 application.
Yes.
Another, before the trial
No,
judge.
that is this application.
That is this application. Before
Yes.
the learned trial judge, the cross-examination of plaintiff's witness was going on, but the learned judge, by order impugned in another revisional application, will ultimately close the witness of plaintiffs. So let that two application be heard together. Since Mr. Mukherjee today have some difficulty.
Where is that application?
That is, may I?
That was filed on a prior occasion. It's 1687 of.
No, the evidence was closed earlier. Evidence was closed earlier, thereafter transfer.
Yes. Thereafter transfer.
No, pending situation.
So let me.
17th of May, my lord, this order, and the evidence has been closed by virtue
What
of
is
the
the
order.
ground for transfer, Mr. Mukherjee?
Lord, I can say before your lordship only looks at not the second page of the order impugned. The quotation.
Niranjan Khana, is this a preemption matter?
No, it's eviction.
This is a reported judgment of Niranjan Khana in preemption.
That is the same party or not, not actually. Perhaps not.
Yes. That's the preemption under the non-agricultural tenancy
Yes.
act. That's the reported judgment, Niranjan Khan. I was thinking that this is whether this is that. Yes, what is the reasoning? What is the ground on which you have sought for transfer?
That's why, my lord, I invited your lordship. Kindly takes up second page of the order impugned.
Yes.
17th May order. My lord, a quotation part is there, my lord. It's a communication between the court and the learned advocate who was conducting the cross-examination on behalf of the defendant. Now, I could have understood, my lord, that a litigant is not reposing faith upon the court, but it's not about the litigant himself. It's the learned advocate, a communication between made, my lord, at the time of doing cross-examination by the conducting advocate and the court. And I have taken a very specific instruction, my lord, from my client that the counterpart of mine, my lord, before the court below, who was conducting the case, he can file an affirm an affidavit stating this fact before your lordship's court also.
That's beside Mr. Mukherjee, if there are two aspects of this matter. One is
it was fine, my lord.
These two. The other is your evidence of closure.
Not mine, my lord, the plaintiff's evidence while I was in process of cross-examination.
So your cross-examination of plaintiff's witness stood closed. So that was earlier to this.
For that, not separate revisional application is pending. I prayed before your lordship so that it can be consolidated hard together before your lordship.
Where are the issues are not the same because
not same, but not touching to the same aspect.
How can it be? Because that closure is a different thing altogether.
Yes.
And
Even if
it's a
I
transfer.
succeed in the revisional application, that revisional application will be there on board. I am not saying that. Since it's between the same parties and today Mr. Mukherjee has having some difficulty, that's why I'm.
Where is that application?
That is pending. This is CO number 1687 of 2025.
It's pending in which
For your
list?
lordship's court, 2025 matter.
Which it's running in the list or it's not in the list?
Listen, not in the list.
Why it's not in the list when it was filed?
Because what happened, my lord, department considered it was a section 24 application, so it was sent before the order just taking up section 24 application. We, my lord, clarified that and got it fixed, and thereafter, my lord, the matter was mentioned so that it can be.
So it is not yet in the list.
Not yet.
So
since between the same party, Mr. Mukherjee.
Yes, when Mr. Mukherjee will be available?
Tomorrow.
Where is he?
He just called me over the phone and asked me to pray with your lordship for this adjournment. He's not well, I believe, my lord.
Not well.
I believe, my lord.
When this matter is taken up for hearing, an accommodation has been prayed.
Appear, my lord, tomorrow.
Yes.
Kindly direct that, my lord. Otherwise, my lord, it will go. 7th is the date fixed. That's why, my lord. Otherwise, my lord.
Please look at the list tomorrow.
But the affidavit of service.
Evidence service filed in court today is taken on.
Lord, may I hand over the another details to your lordships of?
Yeah, he said he has mentioned. Don't hand over that. That cannot be listed now.
Item number 20, can you tag with this matter, my lord, so that your lordship can hear it together? Because
You have mentioned it will appear in due course.
I tell your lordship what has happened, my lord. He learned, but what my friend has pointed out, learned that, but I'm not mentioning is what he expressed his mind. Thereafter, my lord, when the section 24.
That I will consider in section 24.
My lord, other part has to be, my lord, let this
I will
together.
let me see, take up this application first there. Yes.
May I please, just your lordship. My lord, my application is arising from a rejection of amendment application as well as recalling application of that rejection. My lord, what happened, my lord? My lord, the opposite party and the petition is the brother.
You have challenged both the orders.
Yes, your lordship. Lordship, my lord, may I, your lordship? Lordship, both the opposite party and the petitioner both are brothers, Your Lordship. My Lord, opposite party file a suit.
Give me a minute.
Yes.
My Lord, I have to indicate, Your Lordship, since I have read the order, Your Lordship. Admittedly, Your Lordship, this amendment application has been filed after closure of the evidence of the plaintiff's witness. Now, my Lord, what I want to bring under this amendment application.
Where is the amendment application?
My Lord, page 39, Your Lordship. The para 6 and 7 is the relevant portion. What I want to bring is an elaboration of my defense already been taken in the written statement.
Where is your original statement?
My Lord, original written statement, my Lord. Page 26, Your Lordship. Yes, Your Lordship.
Where is the counterclaim?
My lord, on the next, your lordship, after the affidavit, page 32. Starts from page 32.
Where is the evidence of the plaintiff?
My lord, that
PW1.
that may not be a part of this application. No, my lord, we haven't part, my lord. If your lordship permits me, then I can file a supplementary affidavit to bring on record that affidavit is the chief of the PW1.
Yes.
My lord, I want to just bring on record to elaborate my defense already taken in the written statement as well as in counterclaim, my lord.
What is the original case made out which you wanted to elaborate with regard to the lorry?
My lord,
Show me the original case made out in the written statement with regard to the lorry
my
that
lord,
you wanted to elaborate.
my lord, the law, my lord, the entire business is going on.
No, you said you wanted to elaborate the case. So this is with regard to a lorry. Show me the original case made out in the written statement with regard to the lorry, which you wanted to elaborate by
lord,
filing this.
Page 7. My lord, there is no mention about the lorry, but in if you lordship see paragraph 8
The
of
elaboration is there has to be a case in the original written statement. You are
my
trying to, or the plain,
My
you are trying to elaborate.
my lord,
Show me that.
my lord, only my lord, if you lordship see come to paragraph 8 of the written statement, page 27, internal page 2, my lord, I have mentioned about the joint business. My lord,
Yes.
if I say, my lord, there are two part of the amendment, your lordship. That first in regarding the lorry and the other was the regarding the business, your lordship.
Yes.
Lordship, it is fact, my lord, there is no mentioning about the lorry in the written statement, but your lordship, but second part of amendment, your lordship, what I am short to elaborate, that is a part of paragraph 8, the second part, your lordship. If your lordship kindly see page 41 for once the amendment application, the schedule part, your lordship.
Yes.
If in page 41, your lordship, schedule part is the defendant was the owner of the aforesaid lorry. So and so, my lord, this is not mentioned in the written statement, your lordship. But the next part, the defendant was got several documents which shows that the defendant and the plaintiff jointly
Documents, evidence need not be pleaded.
No, my lord.
Evidence need not be pleaded. So the evidences you can prove, you can produce at the evidence stage, that need not be pleaded.
My lord, but my lord, since all the properties these documents are in relation of these premises, your lordship, that I have mentioned.
Produce that, nobody is preventing you from that. Evidence need not be pleaded. So you have stated that. Show me your original written statement with regard
page
to
27,
that.
paragraph
It states
8.
that the entire price against the consideration was paid from the accounts of the joint business. So you can prove that by way of evidence.
Just want to
For
bring
that,
on record, but this because my lord, the business name is not mentioned in this written statement, your lord. The business name. My lord,
name, that is a matter of evidence.
Encon
Joint
affiliates-
business is there. Name is a matter of evidence.
But you kindly allow me to.
This application under Article 227 of the Constitution. Yes.
I am appearing for the petitioner. In this matter, Your Honor, 25 years back, a frivolous suit was filed in 2005. That is
the impugned order.
Impugned order is 72 and 73. That is at page 114. Sorry, it is at page.
Order dated.
Order dated 18 to 19.
18th August, 18 January 2019.
না
ওটা হাইকোর্টের অর্ডার
না হাইকোর্টের অর্ডারটা না ওটা ওই লোয়ার কোর্টের অর্ডারটা বলছি ইমপিউন্ড অর্ডার Your Honor, what happened? This Honorable High Court, this is at page 114, Your Honor.
18 February 2000.
I am referring to page 117 of my application.
Sir, who are you in the suit?
I am defendant number 5, 6, 7, and 8.
All right.
And this.
What is the impugned order?
Order number 72.
At page 180.
Both of you cannot argue at the same time.
It is.
I can permit only one. Please take your seat. You have a chair behind you. Please take your seat. Yes.
Page 118.
Yes. Yes.
The record
This is the order under challenge.
Your Honor, what happened? This order was subject to the order at page 17 of the Honorable High Court.
You, which is the impugned order, which is the order you are challenging?
72 and 73 at page 118. Page 118.
Order number 72 and 73.
73.
So you are challenging an order of 2019 in 2025.
So, Your Honor, this order was as per High Court's order, this application, this was a conditional order that rupees 10,000 was to be paid. That has not been paid.
You cannot challenge an order of 2019 in 2025.
Your Honor, what has
That's your explanation for that delay?
Your Honor, the explanation is this: they have been taking in lower court. They have wasted a lot of time, and the 72 and 73 order has been passed without compliance of the High Court's order.
Always.
That page 117. It was said that
that 10,000 cannot be
rupees 10,000 was to be paid in 2 weeks' time.
Yes, yes.
And rupees
the petitioner.
It was not paid, and the matter was restored. And furthermore,
you cannot be permitted to challenge an order of 2019 in 2025. This application.
The next order is, Your Honor, 92. 92 is at page order number 92. Order 92 is at page 187. 187. It is still going for SRNAD.
What do you want?
I want that the order dated 72 and 73, which has been passed without recalling, and it was direction was given that within 3 months, the miss case 1801 was to be heard and disposed of. In a span of 6 years and 6 months, it has not been done, and it is still continuing in as for SRNAD, page 187.
This application under Article 227 of the Constitution of India is at the instance of the defendant numbers 5, 6, 7, and 8, praying for reconsideration of an order dated 18th of January 2018, passed in CO 3374 of 2017. And for setting aside the order numbers 72 dated 18th of February 2019 in miss case number 632 of 2017 and order number 73 dated 14th of March 2019 in miss case number 1801 of 2005. Full stop. The orders dated 18th of February 2019 and 14th of March 2019, passed in 2 different miscellaneous cases, have been challenged by filing one civil revision application, and that too after a lapse of more than 6 years from passing of the said order. First of the inordinate delay in filing the application
Your Honor,
has not been.
this is already, this is still continuing.
Let it continue. Let it continue. The inordinate delay in filing the civil division application has not been explained. For such reason, this court is not inclined to entertain the civil division application.
Your Honor, let the lower court be directed to decide the matter within a specified time as
the composite application filed on that it cannot be done. File separate applications, it will be considered. For such reason, this court is not inclined to entertain the civil division application according to the same stance dismissed. Yes, next.
My lord,
Liberty not necessary, you can file that. Without liberty also you have. Yes. Yes, Mr. Mukherjee.
Although I'm not caveat.
When you do not have any right of audience.
Above Kolkata Municipal Corporation, I have received instruction to appear.
Yes, Mr. Vadaji, you are appearing for the petitioner. What do you want? What have you done?
Do not open the papers. In pursuance of an order made by the Honorable Division Bench in respect of a 401 proceedings, carried by the private respondent, the opposite party here, an order was made by the Honorable Division Bench that I shall have liberty to approach the building tribunal, assailing the findings returned by the
Special Officer Building.
Assailing that finding. Now, my lord, in course of hearing, I had to take out a Section 5 application, which was supposed to be taken up for consideration. Now, that's in connection with the Section 5, the opposite parties, the respondents in the appeal, not the corporation, they used an affidavit saying that my specific case was that the corporation before the Special Officer Building, I was never heard. I did not participate in the proceedings apart from one notice that I received. That is at page 30 and 31 of the papers. Be that as it may, this Honorable Court relegated me to the tribunal. Now, in the tribunal, in connection with the Section 5, they take out an affidavit, they file an affidavit, in connection with which, in 2 paragraphs, they say that before the first authority, that is the Special Officer Building, I have allegedly, made representations, dates are not mentioned, made representations whereby I have accepted the position. Now, on checking the records, I personally, my instructing advocate checked the records.
What is the order impute?
The order impute, I had taken out an application, saying that this has to be honored because it is not my signature. The document is a forged one. It's a fabricated document. Whatever is on record is not the correct document because I have never appeared before the first authority, that is the Special Officer Building.
Show me the order of the Special Officer Building.
Page 22. The appellate order is at the order of the challenge.
Order of Special Officer Building.
Please come.
Page 36.
Please come to page 36.
নামও রিপ্রেজেন্ট করেনি দুলাল চক্রবর্তী and others উঠেছে. But my name.
I am, one of the co-sharers. I have purchased a portion of the owner's allocation. My name is Papi Chakraborty, not Dulal Chakraborty. Detail of unauthorized occupation, etc. This proceeding was brought against Dulal Chakraborty and others by KMC. The allegation, violation of such and such, infringement such and such, as per report of the concerned bureau, there is complainant named Tutul Chakraborty as per report of the concerned bureau, infringement statement such and such. And then, please turn to the next page. The flat owner's lodged complaint against the construction at parking places preparatory for shop. PR stated that the space is purchased after execution of but the complainant stated the free access.
Who are you, Mr. Vadaji?
I am
one of the
co-owners, whose name does not figure.
Co-owner means you are also a flat owner.
No, not the complainant. Dulal Chakraborty and others, I come within that ambit.
I'm the owner of the land.
No, you are the owner of the land. There was a development agreement with the developer. Developer has constructed So you are also having your owner's allocation. So are you staying there or you have transferred?
Commercial establishments from
I have
Yes.
purchased
So
from the
you
developer.
are one of
the
the,
developer's allocation.
you are also one of the flat owners.
Yes.
Has to be.
Because এখনো আসেনি।
Owner's allocation has been handed over to you unless you have transferred. So you must be in
But
occupation.
that has not been
So
transferred. I have not allocated portion হয়নি কিন্তু এখন।
now,
Actually,
Mr. Bhattacharya, that this parking space is still there.
that has
As shown in the sanction
been
plan, I
regularized.
accept you have not participated.
That is been-
Please satisfy
has been regularized by acceptance of
at whose instance?
at the instance of the corporation.
No. It's applied for regularization.
That we know.
Applied for
No, not at your instance.
32 is
So not at your instance, but you are aware that it has been regularized.
Because my adjacent plot have been regularized.
Is 32 is the document.
You are having that document
Yes.
of regularization. So yes, at whose instance this regularization was made?
Recorded, the demand issue, Dulal Chakraborty and
Who is
others.
Dulal Chakraborty?
Other co-owners.
And some other co-owner.
My
So,
cousin brother.
yes, some of the other co-owners. Have you made him a party?
In the present proceedings, no.
Why?
Because
Mr. Bhattacharya, it was at his instance. Dulal Chakraborty was a party before the SOB. The appeal is not informed.
Please come to page
Mr. Bhattacharya, appeal is not formed, is not informed because the special officer
parties are party.
order was
the private
passed.
party, the complainant
party.
But Dulal Chakraborty was also heard. He was also a necessary party. One co-owner against him, an order has been passed. Other co-owner, without making him a party, you are.
Your Lordship is correct. Why I did not make him a party, I'll tell your Lordship. This, if your Lordship kindly takes the trouble to come to page 40.
Because you are challenging, Mr. Bhattacharya, you are challenging an order of the special officer building, wherein
Building by the BTAP. In the BTAP. Yes, a special officer building.
so in effect you are challenging this.
The appeal is against that order.
In effect you are challenging this. The Kolkata Municipal Corporation says it has proceeding has to be against the person responsible. Person responsible has been mentioned as Dulal Chakraborty and others. Who are the others?
I come within the ambit of others.
Yes.
Apparently.
Not apparently. So if some of the persons responsible have approached, the other persons responsible are not being made a party. And according to you, some of the other persons responsible have got this parking space regularized.
Please see page 41. Please see page 41. 41. চক্রবর্তীর মামলা দেখে
চক্রবর্তী is the complainant.
Yes. Page 41, I am at page 41.
The writ petition.
দুলাল চক্রবর্তীও ছিল।
It is their writ petition. From I came to know that an order has been passed against me.
Now,
So you have applied for addition of party. Whom did you pay for addition?
No, I am not applied for application of party. The private
an
respondent.
advocate appearing for the appellant submits an appeal was
Who
filed.
is the appellant?
And I am the appellant.
Yes. Please kindly come to page 42. Fifth paragraph. Court is informed that the private respondent before us applied in the pending proceeding before the building tribunal for addition.
Yes.
Who are the private respondents? The complainant.
Tukul Chakraborty and
Complainant. So you have also not implemented the complainant before the municipal building tribunal.
Yes.
You have not implemented. So the private respondents got themselves added in that proceeding.
And I have impeded. Now it is
No,
their
no.
parties. And
Now they are parties because on their application. So you approach the building tribunal without making the other persons responsible a party, without making the complainant as a party.
That is another aspect of the matter.
That is the main aspect of the matter, Mr. Bhattacharya.
Your Lordship is looking at an order.
The root of the matter. The root of the matter from where this problem arose.
The issue is today the tribunal before whom the appeal is pending on being informed about paragraph 9 and 13 in the affidavit that there are certain representations made on cross-checking those. My Lord, I find that there are certain signed documents. Apparently, my signature has been forged. I don't have an access to the document. I don't have any of such document. I wanted to bring it to the notice of the tribunal.
What are those representations? Have you annexed that?
No, I don't have access.
All right. How do you know that that apparently
Inspection.
inspection? So you have not got copies of.
Don't. And even
They have
even
used an MDB.
please see the affidavit stand.
Now, what was your application before the building tribunal?
Please come. Now, please come to impugned order.
Yes.
Now, please come to page 23. Learned advocate for the appellant, learned advocate for the appellant submitted that from the affidavit filed by the respondent in this appeal, the appellant came to know that a representation dated 14 March 22 purported to be written and signed by this appellant was submitted by the special officer building during demolition proceeding. The said representation was neither written nor signed by this appellant. The said representation dated this is forged and fabricated. The said representation addressed to the special officer is lying with the CR of demolition proceeding. The said representation be kept in safe custody as the same is apprehended to be taken out of the case record. In the circumstances, necessary step to conduct thorough investigation is required with respect to the fraud committed by the private respondent. Learned advocate for the private respondent submitted the representation dated 14 March 22 was part of the proceeding before the special officer. It's absolutely incorrect. And the appellant being present and having participated, I did not participate. Learned advocate for KMC raised strong objection and submitted the appellant ought to have agitated about the matter.
No, Mr. Bhattacharya, only one thing. The allegation is, those are the extraneous matters in order to enlarge the scope of an appeal and for other purposes. But the main matter is that allegation is that some parking lots have been converted. It's a G+4-storied building. So according to you, it has been regularized. Where is that order of regularization?
Demand notice have been made.
No, the demand notice, page 27.
No, plus show me the order of demolition, the order of regularization.
So this order is, if your lordship kindly sees.
If it is not at your instance, you say that you are not the person responsible, you do not also have a right of appeal. Because according to you, nothing was done against you. It's only the person responsible against whom that order was passed.
1/10/2021 to 2023 at page 32.
Page 32.
Yes.
Yes.
Please see fourth line, charge for regularization.
Charge for regulation of authorized construction. Show me the order. Where is that?
That order we don't have. At least it is not a part of the records here.
Do you have a copy of that? You must be having. You are having this demand notice. You must be having the order.
I'll tell you one. This order is after the demolition order. This order is dated 23rd, 21st of February 23. If your lordship sees the order made by the special officer building.
Show me that order, regularization. End of the matter.
Page 36.
You are having the demand notice, Mr. Bhattacharya. You are not having the order of regularization. It's difficult to digest. Because you are having the ultimate thing, but you don't have the basis of that. For what regularization? What has been regularization?
Now,
what fees is that?
This
now, if according to you, Mr. Bhattacharya, if according to you, after the order of demolition, it has been regularized. Without going to that, Mr. Bhattacharya, without going to that, produce the order of regulation before the appellate tribunal. End of the matter.
Now,
if the order is demolition order, thereafter it has been regularized. Is it necessary to go into that?
After the order at page 36.
Yes.
The order at page 32, I'm sorry.
Yes.
A writ petition.
It's not an order. This is a demand notice.
Demand. After this, a writ petition was carried by the private respondents here, in this honorable court.
For execution of the order.
For execution of the order of demolition. Now that writ petition, I contested the writ petition. Ultimately, an order was not made in my favor, from which I preferred the appeal. Before the appellate court, I took the specific stand that before the special officer building, apart from one notice received by me, I did not receive any notice. Now, the honorable court relegated me, the honorable division bench.
Mr. Bhattacharya, these two things cannot go side by side. if you say that there was an order of demolition, I did not participate. In the next breath, you say, then those demolition, illegal construction has been regularized.
An order.
So if that is regularized,
An order has, an order
on which you are relying upon? You are relying upon your challenge to the demolition, or you are relying upon the regularization order?
Not the challenge. I have to rely on the challenge to the demolition because
you are not relying on the regularization.
Regularization was never given any effect to. Apparently, that is what appears. Mr. Chatterjee will be able to assist your lordship better to that extent. The regularization part, this page 32, may have been issued the demand, but it is yet to be executed. In fact,
and you have paid the amount.
No. At least to the best of my knowledge,
only the demand raised.
The demand has been made. Proportionate shares about who is to pay how much is not there. It's not clear. Assuming, the demolition, the regularization order is in my favor. I am today before your lordship's court on a very elementary issue. Apart from any other.
If the regularization order is there, the order of demolition amounts to be impliedly set aside by the order of regularization.
What your lordship may very kindly do, for the ends of justice, I'll serve notice on everyone. I'll come back to your lordship. For the Friday is the next day, before the Thursday is the next day, before the kindly
before the
tribunal.
What will happen?
Let the tribunal wait. For 7 days, we'll take.
What will happen before the tribunal?
I want to come, thoroughly with all documents and papers, whatever writ petition, appeal, everything, so that I can persuade your lordship that there is no foul play anywhere.
I'm not on the foul play. I'm not on the foul play.
The only I am telling your lordship, when it has fallen from your lordship, as to why everyone is not a party here, that aspect of the matter needs to be gone into. That aspect is also a very serious aspect.
Chairman of the proceedings comes from
Why have you not made them?
বিল্ডিং ট্রাইব্যুনাল থেকে গেছি বিল্ডিং রিট পিটিশনটা ওদের
কনফারেন্স করো ভাই বাড়ি দিয়েছেন ছবি দেখি
Because you are, Mr. Bhattacharya, you are on the content, this forgery, fabrication, the appellate tribunal have given you liberty to take appropriate steps for that.
For that, I have to get hold of the document.
Yes, yes. For that, that is a different thing altogether.
The entire copy record. That they don't give certified copy. This is like case records.
So why the main appeal hearing should be stayed?
I am not asking your lordship to stay.
Then
there are two directions. One is the direction for cost. One aspect. Second is the matter has been kept for hearing, further hearing on Thursday.
So cost part. Cost part I can. Cost part is a separate thing.
Your lordship may speak.
Yes.
But the other issue is I have to persuade that then let me take my chance tomorrow.
So section 5 hearing and the stay application hearing are there. So, Mr. Bhattacharya, I can direct the tribunal to hear out that section 5 and the stay application on that.
The section 5, the premise of section 5 is that I have already made applications which have not been signed by.
No. Section 5 is.
Section 5, they have taken that point.
Yes. Section 5 is delay condonation. That cannot be on merits.
They have taken the point.
Maybe, Mr. Bhattacharya, they have taken the point. You have to apprise the tribunal what is the issues which are to be decided in an application under section 5.
Section 5, because I have gone much beyond the time, because I was proceeding in the High Court, the Honorable Division Bench, certified copy was also not made available. It sees the Honorable Division Bench's order, it was purely at the instance of the Honorable Division Bench that the certified copy of the order of the Special Officer building was made available. After it was being made available to me, I took steps to file the formal appeal, and thereby there was substantial.
What is the period of delay?
30 days.
No. 456.
The total delay is 456.
Because no order has been communicated to us.
456 days still.
Yes.
You serve a copy.
Before that, if you let him produce. He has also filed a writ petition. Let him produce the writ petition, copy of the writ petition.
Challenging.
That copy has not been kindly seen.
Yes, Mr. Bhattacharya, you have filed another writ petition.
8573 of 2025, Bapi Chakraborty, Kolkata, 13 June order.
Regularization. Regularization.
It should be dismissed with cost. This division has to be dismissed with cost.
Yes, Mr. Bhattacharya, for what?
Regulation, challenging the regulation, kindly. And this honorable court entertained and directed the corporation to
my shoulder, I should have been properly stopped.
This has to be dismissed with cost.
Representation consideration explain.
এটা মামলাটা কিসের?
রেগুলারাইজেশন চ্যালেঞ্জ করে আছে ওটা।
রেগুলেশন চ্যালেঞ্জ না, রেগুলেশন করা হয়েছে তার রেসপেক্টে। সেটাকে যাতে সেটা সাবসিকুয়েন্ট টু দিস
It has not been stated here, my lord.
I take it on my shoulder.
When this civil division application, no.
This will not prevent the tribunal. This will not operate as stay, my lord.
It is not.
For payment of cost part needs to be.
Mr. Bhattacharya, payment of cost, if this is there, I do not know.
This is something different.
Or I am not saying anything because I do not know if there is suppression cost. I have
Your lordship will keep it day after tomorrow in that direction.
nothing. Yes, next.
As your lordship.
Item number 23.
The petitioner, I'm praying for not this week. I'm praying for not this week, my lord.
Why?
The learned advocate on record is ill. He will not be coming.
On the prayer of the learned advocate.
My lord, this is my application for expeditious disposal in respect of a money suit filed in the year 2014. The written I am for the plaintiff in the money suit. The defendants filed their written statement. The issues were framed, but in 2018, the money suit was dismissed for default due to non-appearance of the learned advocate. So we filed a restoration application. The restoration application was dismissed in the year 2023 for the same reasons. So we filed another miscase to restore the original miscase application. And my lord, now the miscase is not proceeding. Adjournments after adjournments are being granted.
Service returns appearance, parties have not appeared. This application. to appear. Yes, call the next matter.
My lord, I beg pardon, my lord, to item but earlier, my lord, 23, my lord, I appear for the opposite party in 6 and 7. It is 27 item. I am wrongfully appeared.
Oh, তাহলে আগেরটাতে what is that item number?
23.
23 টাতে না opposite party appearance টা কেটে দিন. Yes.
My lord, item 25, I'm for the petitioner. In 2020, I'm again praying for expeditious disposal. This was my suit for an order praying for injunction, perpetual injunction. The defendants are the same. There are 3 matters between the same parties.
Sir, you have been directed to take steps. You are not taking steps. Applying for expeditious hearing.
My lord, we have.
I think this type of applications are to be dismissed with
My lord,
cost.
we have served, my lord.
All right.
The service is
This application under Article 227.
Item number 26. 26, Lord, I am appearing, Lord, for the petitioner. This my application for amendment of the plaint has been rejected. I'm the plaintiff in a suit for a declaration.
You have got copies.
Yes, I was on. I'm closing the application, my lord. Yes. Lord, your lordship may kindly directly come to the impugned order. Thereafter, my lord, my point will be before your lordship that the learned judge has said that my application that I seek, my lord, for an amendment of the plaint.
After the impugned order, Mr. Mukherjee, what have you announced?
There are
notarial certificates.
I know, my lord. This is not the practice, but Lord, nowadays.
And you have not filed a certified copy also.
There was a leave, I am told, my lord. And there was a leave because of an urgency.
You have not yet obtained the certified copy.
Apply করেছিস? He has applied, but it is not, my lord.
Yes, 12th of June 2025 is the impugned order.
12th of June 2025. Kindly come to, my lord, after the portion heard considered. I'm not concerned about the previous one.
Yes.
I'm only concerned about, my lord, my 2 applications, one for amendment of the plaint, the other one under 151 for amendment of the injunction application. I got an order of injunction in connection with my suit, and my lord, there was an addition of party. Because of the addition of party, my lord, I wanted, my lord, to amend my plaint. But initially that was rejected, my lord, in the year 2024.
What was rejected?
An application for, my lord, amendment of the plaint.
Yes.
That is, there is another CO. There's another CO pending before this honorable.
Challenging that rejection of amendment. Now, what is this order?
And this is, my lord, another application was made. It was bit differently. But the learned judge rejected amendment of the plaint.
So you are not pressing the earlier one?
No, that is also before your lordship. Appear করছেন order. Not appearing. And this is not the subsequent
amendment sought for a different.
The learned judge has not recorded that. Your lordship will kindly come to the impugned order. Lord, I'll just point, Lord, 2 pages before your lordship.
Yes.
But after that portion of, Lord, the impugned order, page 2.
Yes.
After, Lord, heard considered, I have gone through the case record and it is found that the plaintiffs have come with this set to application seeking amendment of the plaint, as well as temporary injunction application after passing order by the Honorable High Court, Calcutta. This was not for expeditious disposal of, Lord, the injunction applications, whereby the Honorable High Court has been pleased to observe. Since
that is the direction for expeditious hearing.
But that was, yes. With regard to the contents of the said to application, it is observed that the plaintiff are praying for amendment of the plaint and temporary injunction application. Page 7 bar kore rakh. It is observed that the plaintiff are praying for amendment of plaint and temporary injunction application for the reason that one international hospital limited has been added as a party defendant in the suit, and on the same contention, the plaintiff made the previous application for amendment of the plaint dated 7/5/2024. Though the schedule of the proposed amendment in application dated 7/5/2024 and the application dated 11/6/2025 and 12/6/2025 are not but different, but the purpose of seeking amendment was is
No,
similar and identical to the
Mr.
same petition of the,
Mr. Mukherjee, two applications
my lord.
filed on successive dates, 11th of June and 12th of June.
But one under 151 for amendment of the injunction application and one for amendment of the plaint.
Earlier was on 7th of May 2024.
That was rejected, a civil revision pending before your lord.
Mr. Mukherjee, only one thing.
Lord.
Maybe I take your submissions that the proposed amendments are different in these two applications. But if the second proposed amendment was available at the time of first proposed amendment and that was not sought for, then whether this impugned order.
I will show Lord, that the second application was based upon not a subsequent event which was necessitated by my client. That is exactly Lord.
That is a subsequent
Yes,
event
because of
after the first application.
after the
was,
first application. If your lordship desires, your lordship may add.
have to be heard together.
Which
Yes. CO2.
Both the applications are it's appearing in the list.
No, Lord.
Not in the combined list also.
Not before your lordship, Lord.
Then
it was filed before Lord. Lord, I'll mention your lordship may direct Lord that the matter may be tagged together. There is a 2024 matter.
2024. Difficult.
The learned judge has not even applied the mind about the substance of the amendment application. Only says that well.
Because the two applications, unless they are,
I understand, Lord.
or because there may be some.
I understand. Whether Lord that the learned judge is not reasoning that it was a malafide application.
Malafide, yes, but whether this proposed amendment was available at the time when you filed the earlier application, but that is also an important thing to be taken note of.
it was. I'll demonstrate it
Lord,
from this
but
amendment
the learned
application.
judge says Lord that it was bit different.
No, maybe different. Mr. Mukherjee, yes. The learned judge says different. I'm not saying same. I'm not saying that you have made the same amendment application or the proposed amendments in two different applications. But the fact remains, there are maybe two cases. One is that after the filing of the earlier application, certain subsequent events took place for which you wanted to incorporate a subsequent application may be maintainable.
Lordship.
But if the facts which you sought to incorporate subsequently was available at the time of the initial application, but not sought to be incorporated in the earlier application,
Principals acting to order to rule.
then the the finding may be observations may be right. Because malafide may come into play at that.
Learned just says
May
that
not
I'm trying to delay.
I'll show it from the
Because
amendment.
if it was delay is also one of the part. So
No.
for that malafide comes.
Attempt to delay is a different thing. Lord, for that reason, the court should not
Because Mr. Mukherjee, I
dismiss
give
my
you an
application
example.
without an application of mine.
If three facts you want to incorporate, all available at one point of time, in piecemeal way, you are filing 3-4 applications for bringing all those facts which were available at the initial, though may not be technically speaking commencement of trial, but even if there commencement of there has not been any commencement of trial, even the delay can be looked into while considering an application.
But I'll certainly try to answer your lordship. This is a suit of the year 2023. So not the question of inordinate delay, but not the question whether it was available before and I did not pray for that amendment in 2020.
Because there are
that your lordship
some
may
a line of decisions where you will be finding that if that was available at the time of filing of the original plaint, or that if that principle is applied here, so available at the time of filing of the original application for amendment.
Lordship.
So whether subsequently that fact can be, there are
Brought
some
out
line
by
of decisions. You will be getting that in amendment when the proposed amendments were available at the time of filing of the initial suit or at the filing of the written statement, but not brought in at that point of time. Subsequently, you are trying to incorporate that delay. That fact also can be taken into consideration. But after all, the basic thing is that whether the proposed amendments are necessary for the purpose. That's the ultimate.
That's
That's the ultimate test. But these facts can be taken into also.
That the learned judge did not advert to it at all.
But when to be taken up, because these two.
And Lord, they are not taking Lord each and every day, Lord, they are trying to Lord have that Lord the injunction order vacated.
I'm entitled to that. He's enjoying the interim order for almost 2 years. I'm not doing something which
Because
is
I'm
wrong.
entitled to an interim order. That's the reason I'm
Let it be
enjoying that.
tested out once and for all. He cannot enjoy it forever, especially when there's a High Court order
Where
saying
the
that
file is lying,
June
where
has to
the
be
other
decided.
file is lying.
Other file department. But I'm told in the department. So number number
Not just delay, but also timing. Once this High Court order comes, finished by 30th June, then they make up conduct. No step taken with regard to the other revision application.
Mr. Mukherjee, learned senior advocate, appears for the
Shouldn't they try?